This is one of those questions that requires kind of a multi-part answer. First, if the case is still pending, the Federal Rules of Bankruptcy Procedure do permit you to amend your schedules to add creditors. But there is a bit of a wrinkle here. Now, if after the case has been closed, you want to reopen it to add creditors, the answer is no. So how about a little bit of background here on what's really at work? One kind of a debt that's not dischargeable is a debt that you didn't list in your bankruptcy papers in time for the creditor to do one or some combination of two things. What are those two things? Number one, the creditor didn't get a chance to file what's called a proof of claim. And the proof of claim is the way that the creditor gets added to the list of creditors who get paid out of assets of the bankruptcy estate. So if, for example, you have a Chapter 13 or Chapter 11 where there's a plan of reorganization and you're going to be paying creditors, but you didn't list that particular creditor, the creditor never got an opportunity to file a proof of claim in the case and therefore never got a chance to get paid. Well, that creditor was prejudiced by not having been listed. The second thing that the creditor is supposed to be allowed to do is challenge the discharge of that debt under one or some combination of theories of fraud, breach of fiduciary duty, or willful and malicious harm to a person or property. But if the creditor didn't get listed, it never got notice. And if it never got notice, it never got its bite at the apple. It never got a chance to challenge the discharge of that particular debt. So as a result, the Bankruptcy Code has this provision, Section 523A3, for those bankruptcy nerds that like the details, that says that if you don't list a debt in time for the creditor to either file a proof of claim or challenge the discharge of that particular debt under one or some combination of those three theories, the debt is not dischargeable. Now, there is a Ninth Circuit Court of Appeals case called In Re Beasley that adds a new dimension to this particular provision. So the context is this. Beasley filed a Chapter 7 bankruptcy. Remember, the big picture goal in Chapter 7 is just to wipe debts out without paying anything to the creditors. Well, Beasley's Chapter 7 was a no asset case. What does that mean? Well, it means that there were no non-exempt assets for the Chapter 7 trustee to take and liquidate and have money to distribute to the creditors. Well, Beasley got his discharge, the case closed, and later on he thought, oh, I forgot to list creditor ABC. He filed a motion to reopen his case so he could amend his schedules to list that particular omitted creditor. The bankruptcy court said that's not a good reason to reopen the case and denied the motion. Beasley appealed and it went bubbling up to the Ninth Circuit Court of Appeals. The Ninth Circuit said the bankruptcy judge is correct, but we are going to give an explanation so that in future people can know why this isn't a good reason. So they pointed out that, number one, if the case is a no asset case, then the creditor was not prejudiced according to that first thing that the creditor gets to do, filing a proof of claim, because filing the proof of claim would have accomplished nothing since there were no assets that were liquidated by the Chapter 7 trustees, so there was no payout. And if there was no payout, well, how was the creditor prejudiced by not having been listed? The second issue here is, well, the creditor never got its bite at the litigation apple. It never got a chance to challenge the discharge of that particular debt under a theory of fraud, breach of fiduciary duty, or willful and malicious harm to a person or property. The Ninth Circuit said, look, there is no point in, even if you could reopen the case and add that creditor, there is a clock that's not going to be restarted. Now, little side note, what do I mean by this clock? When you file a Chapter 7, something on the order of a month, plus or minus a few days after you file, you go to a hearing. It's called the meeting of creditors under Section 341A of the Bankruptcy Code. When you walk out of that hearing, a 60-day clock starts to tick. If you get to day 61 with the understanding that if that's a weekend or a holiday, it does spill over to the next business day. If no one has initiated an adversary proceeding to challenge the discharge of a particular debt under a theory of fraud, breach of fiduciary duty, or willful and malicious harm to a person or property, they forever lose the right. Well, in Beasley's case, suppose he had reopened the case and listed the creditor. Well, the creditor can't file that adversary complaint to initiate the adversary proceeding because the 60 days are long since passed. So it wouldn't have accomplished anything at all. So what the Ninth Circuit ultimately said was, in a no asset Chapter 7, if the debt would have been discharged, it was discharged. And if the debt wouldn't have been discharged, then it wasn't discharged. Now, that still raises the question, what if I'm the creditor and, okay, it was a no asset case, but I really think I could have won on the fraud thing. So you say if it would have been discharged, well, I'm saying it wouldn't have if I'd gotten my bite at the apple. But the 60-day window is passed, so I can't file the adversary to challenge the discharge of the debt under a theory of fraud, but I could file an adversary under a theory that you didn't list the debt in time for me to do this. So you wouldn't be appealing to the fraud issue. You'd be appealing to the failure to list the debt. That would initiate the adversary proceeding because with that particular adversary, there isn't that 60-day window past which you're barred. And so you could sort of bootstrap your way up by initiating the adversary to challenge on the basis that the debt wasn't scheduled, and then have a determination that the debt would not have been discharged had it been scheduled, and therefore it's not a dischargeable debt. Kind of a long-winded answer, but I think it's important to kind of get the complete picture rather than just bits and pieces.